Welcome back to episode 3 of The Legal Alternative. We're back, Nils. New look, feedback to look at each other so we're not sat next to each other. So yeah, episode 3 of the new podcast. As always, summarising the news in the legal industry, both employment and regulatory. What we got coming up today, Nils?
So I'm going to discuss what's in my inbox.
Yep.
I'm going to discuss some immigration law changes. Then we're going to do the usual outside the office, and I think we've got an interesting maternity question.
We do. So Nils, kick us off.
So some big changes in relation to immigration law, particularly going to affect care providers.
Yep.
I've got the government release in front of me. So new rules were laid in Parliament on the 12th of March that from the 9th of April, care providers who want to recruit a new worker from overseas are actually going to have to prove that they've attempted to recruit a worker from within England who needs new sponsorship. So you may remember we discussed on the old version of the podcast what used to be the situation before Brexit with what was called the resident labour market test. Similar-ish to that, and what the government says is that significant work has been ongoing across government in collaboration with the care sector to ensure high standards across the immigration sector and to support care workers, into alternative jobs when their sponsors had their licence removed. So what this will look like, it's also designed to tackle exploitation as well, particularly those who are using short-term student rooms within the care sector. So what will happen is you will actually have to show that you have looked within the domestic pool of work, first of all, and the government's provided an email address that providers can go to, where they've then got to contact them to show that you have looked within the domestic pool. The new rules are designed to reduce the potential for abuse, as the government says, keep standards high. So what the government says, and this is Stephen Kinnock, that they wish to prioritise care workers who are already in the UK to get people back to work, reducing the UK's reliance on international recruitment and make sure our social care sector has the professional care it needs. So what has also happened at the same time is that the minimum salary thresholds have been updated to reflect the latest data from the Office of National Statistics. So those on a skilled worker visa will now have to be paid a minimum of £12.82 per hour. So some big changes there for health providers in particular. So both the hourly rate going up and an extra layer of red tape. There is an exemption. So if someone within the country is already being sponsored by a social care provider by a legitimate route, then the new rule to look at that domestic pool first won't apply.
Interesting update. Obviously, I've got personal involvement, as you know, Nils, in the care sector as a trustee. So big potential changes. I think there'll be some cynicism as to, that looking domestically. Obviously, part of the issue at the moment is there is a massive shortage. So how that is going to actually affect numbers, I would have some questions over. As you say, the salaries continuously going up, I think, is going to present a barrier in care, which is already really struggling financially. So there, obviously, I think we always try and err on the sides of politics, but it's some interesting issues that are going to be difficult to manage, I'd suggest.
Two very big barriers now, potentially.
Yeah.
Overseas individuals to work within your care organisation. I mean, the reading of the announcement, it says, we wish to crack down on shameful rogue operators exploiting overseas workers here in the UK. Yeah. And also talks about the fact that 470 sponsor licenses in the care sector were revoked between July 2022 and December 2024. Yeah. So I can see the logic behind it from that front, but for every yin, there's a yang.
There is, and ultimately
difficult to recruit.
Yeah, and safety is the issue in care ultimately, and that's always going to be the challenge with immigration. If we've got unsafe environments due to staff shortages with quite restrictive immigration laws, it's a very, very delicate balance.
Yeah.
Good, interesting, Nils. Well, as I say, keep us updated on that. In terms of my inbox, I've got a bit of a discrimination case to share. We've talked a lot, Nils, about obviously when you get to tribunal, the difference on a day and depending on what judge you've got and the litigation risk. And these two cases I thought were interesting, because it really demonstrates that, because they've got really similar factual backgrounds, but they've been decided in a different way. So I'm just going to talk through them briefly. We've shared the detail of the cases on the Monday Morning Dispatch newsletter, but the cases, and apologies for my pronunciation, Soidag versus St Anne's Catholic Girls' School and Huggs versus Farmer. Two cases, both involving discrimination on the ground of someone's religion or belief. So these are both cases that involve two practicing Catholics, both working in schools. And to different extents, publishing comments online that the school have claimed has damaged their reputation. So the first case, Soidag versus St Anne's Catholic School, this involves a case where the claimant was a pastoral manager at the school, had nearly 40,000 followers on social media, which for a school pastoral manager I thought was quite impressive. She posted content that promoted the idea of biblical marriage and posted some comments essentially about women who are married and wives being subservient to their husbands and the importance of them kind of, if the case says about it, if the husband says jump, I do it, kind of thing. Right. So obviously some comments that can be quite controversial. And from the school's point of view, especially working in an environment with young girls. So they were posted, brought to the school's attention by a parent, which the claimant was then asked to remove the posts, removed one of the posts but not the other, ultimately dismissed. School did so on the basis of this caused damage to their reputation. Claimant argues, as there often is the case, that these are a matter of personal belief, that she had entitled to that belief. Ultimately, this claim in unfair dismissal and discrimination is dismissed. Judge holding that the claimant had a concerning lack of awareness for someone whose role involved the care of 14-year-old girls. Such the claim fell down because although she was allowed to express her views, the school could show it was reasonable, and that key word reasonable, into a decision to remove her because of that damage to her reputation. So that claim falls down. That is then in absolute contrast to the claim in Higgs. Again, pastoral administrator, basic background, shared posts that were critical of the LGBT plus community, criticism of her son's school of introducing transgender books and themes. Again, we've got an anonymous complaint into the school, which was then resulted in disciplinary action being brought. As always, we've got the same arguments, ultimately from the claimant, that this was personal beliefs, right to her own beliefs, right to privacy, and was expression of her faith. This claim eventually reached the Court of Appeal, and ultimately the decision of the Court of Appeal was that the dismissal was unfair because it was disproportionate and violated her religious beliefs. The school's defence that this damaged reputation apparently lacked evidence and support. So two really similar factual cases decided in completely contrasting views. And I think one shows the difficulty of these types of social media, rights of privacy type arguments in discrimination. If anything to kind of takeaways is it's the key if you are, in this case, the school's respondent defending these types of claims, is that if you are showing the justification argument, essentially, in this case, the damage to your reputation, it has to be evidenced. Yeah. It just can't be theoretical. So the first case, they were able to show that opinion was reasonable. Second case, the view of it being disproportionate. That is a really fine line. So and I thought it was really useful two cases to highlight that point of reasonableness is really difficult in these cases. Yeah. Don't know any views, Nils?
The first case, I was quite surprised when you said that she lost. I was expecting you
the other way around.
Yeah, I was expecting you to say that the dismissal was outside of the band of reasonable responses. Yeah. But it shows, as you say, the variability. I don't know if you remember the Keith Mason Huddersfield case. I think there's always going to be an element in those cases of, as you say, can you prove the damage to your reputation and which judge you get. I think it is as simple as that, really. But I was expecting you to say the first one, that was outside the band of reasonable responses to make that dismissal.
Absolutely. And, you know, what we say to lots of our clients, it's that risk on the day. And obviously, if you can have what looks like a very watertight defence can go one way, and then same facts, different day, goes the other. So, interesting cases. Obviously, as always, any of the clients, any of these types of issues, let us know. I think always a good highlight for anyone going to the tribunal in terms of how the cases are dealt with. Out of the office, Nils, what have you been up to?
Well, I am going to watch Huddersfield Town at Lincoln tonight. And I did just want to say, I went to watch Huddersfield Town versus Crawley, which was a better result than the Charlton one. And Peter Jackson, Nathan Clark and Andy Booth looked after us absolutely superbly that day. And Peter Jackson in particular was absolutely fantastic company. So I just want to say thank you to our friends at Huddersfield Town, but looking forward to, fingers crossed, the Terriers getting back to 3 points tonight.
Yes, very good. I'm off next week. I'm off to Turkey for a week, so that'll be nice. Getting a break, a bit of Easter sun, which will be nice. And apart from that, I'm running a lot. I think I mentioned before, in future podcasts, doing I'm marathoning again. So training 30k last weekend. So getting up to some nasty distances. But having a week off in Turkey too, obviously. Healthy retreat, no food, no alcohol, just training, clearly.
Definitely no gyros.
No, exactly. Finally, Nils, questions from social. Again, we've had a quite heavy on the employment questions. So please, listeners, get some regulatory, some immigration, some crime questions for Nils. I've got a question today, anonymously shared, and which I thought was a good one, which I'll read the question out. So we have an employee going on maternity leave, and she was asked if she will still get commission. Quite a simple question. For me, we talked about it before. These are very difficult issues, and I thought I'll read out the statutory definition because it's quite helpful here. But we get these questions a lot about commission, but then some of them which are even more technical about salary sacrifice arrangements, about childcare vouchers, about company vehicles. And the starting point in the legislation, I'll read it out, is that the employee has a statutory right to the benefit of all the terms and conditions of employment which would have applied had she not been absent, with the key, except terms and conditions about remuneration. Remuneration then is in turn defined as sums payable to the employee by the way of wages or salary. So that's the key definition. So essentially, when someone is on maternity leave, everything remains the same apart from their pay. So then going back to the question from the listener, commission. So the technicality is really how the commission is paid. But generally, commission is paid by the way of salary and wages. It's normally paid within someone's wage packet as an additional amount they get each year. So for that question, with some confidence, I would say no, they're not entitled to that commission. Where, as I say, becomes much more difficult is areas such as company cars, childcare vouchers, which are often more a benefit in kind. And there's some very tentative advice from the European courts, but in particular about things like childcare vouchers, where they say they think it's remuneration, but are not quite sure. So bit of a minefield. Obviously, clients, any questions about it, something absolutely need to get some advice on, because it's risky, and obviously we've got discrimination issues if we get it wrong. I don't know, any thoughts, Nils? I might have answered it for you.
Just to say that when we were talking about that off air, I got the answer completely wrong.
You did.
So I would have thought, and as I say, I haven't done, she would have been, you should be paying this. So it's a good question.
It is a good question. So as always, drop us your questions on socials, and we'll ask them. Get some regulatory questions in. It would be great. That's it for me, Nils, this week. Any final comments?
No. Hope everyone has a great Easter, and looking forward to seeing you all when we get back.